He then says the campaign against anti-Semitism, by the misleading and partial way it summarized its application and its willful, repeated failure to meet disclosure obligations, demonstrated that its true and sole motive was to have Hunter cancelled. He states he has no doubt the prosecution is abusive. He adds that while one category of items did not, in his view, need to have been disclosed, his view of the organisation's conduct is consistent with them as an organisation not playing it straight, but seeking to use the criminal justice system for improper reasons. Then he gives an order that has consequences beyond this case. A copy of the judgment must be disclosed by the organisation and attached by it in all future applications. And finally, he quashed the summons. The two things that matter most there are motive and remedy. A court stating motive in those terms is not routine. Judges generally avoid ascribing intent where they can decide a case on narrower grounds. Here he does not just decide on a technicality. He describes conduct, he describes deliberate withholding, he describes a purpose, and he labels the prosecution abusive. That shifts the organisation out of the category of good faith complainant who went too far, and into the category of actor who tried to use criminal process as a weapon. And then there is the remedy. Quashing a summons ends a case. Ordering an organisation to attach the judgment to all future applications is the court saying that ending one case is not enough because the risk lies in the applicant's conduct. That order means any future judge faced with a summons application from the campaign against anti-Semitism is meant to see the warning in advance. It forces transparency and it forces the organisation to carry its own adverse findings into the room. That's how you lose the benefit of the doubt for a long time.